changes some of the protections that are available. As I look, I present this graphic generally because it shows the value of a utility patent. A utility patent is sort of the gold standard for protection of intellectual property of any kind. And it is available for plant varieties, for traits, and for many things that are related to plant inventions. I also like to show this slide that talks about the value of a patent for a startup or for a university. The first patent that a startup gets increases the startup's chances of securing funding over the next 3 years by 47%. So a utility patent on a plant or plant-related invention is valuable and results in, it can also increase the investor's initial public offering by 128%. So utility patents on plant varieties are definitely worth pursuing if we can. So let's go into what kinds of patents are available for plants and plant varieties. The first that we'll talk about is a utility patent, and that is the patent that everyone has heard about you would use to protect, for example, a mousetrap, software, anything like that. Utility patents are available for plant varieties, and the requirements are that it be novel, it be non-obvious, and you need a written description to enable others to make and use the invention. The patent statute was drafted as kind of an exchange where you need to provide access and information about your invention to the public in exchange for a 20-year period of exclusivity of the right to exclude others from practicing that invention. So for plants, often we satisfy that enablement requirement where you need to describe the patent and enable others to make and use it by a seed deposit. And we'll talk a little bit more about that later. A utility patent gives 20 years from its filing date of exclusive rights to exclude others from practicing the invention. And it is an exclusionary right. It gives you the right to stop others from making and using your invention. It may or may not grant you the right to practice the invention, which is a little bit of a subtle distinction, but it does matter when you talk about things like stacks. For example, one person might have a patent on the transgenic or the gene that you might want to insert or breed into your variety. Your patent on the resultant variety may or may not give you and grant you the right to use that gene that has been inserted. You might need to license that from somebody else in order to be able to make and sell your variety. Another aspect of patents that are available for protection are plant patents. Now, plant patents are different than a utility patent. A plant patent is a result of a modification of the patent statute that happened in 1930. At the time, they thought that utility patents were not available for plants because they thought there was no way to satisfy the enablement requirement. This was pre-deposit. So a plant patent is a similar patent that is issued by the patent office. It is designed exclusively for asexually produced plants. So if you think about why this might have come into existence, the idea of an asexually produced plant, which is not going to recombine and not going to be crossed with other plants, the enablement requirement now seems like it's something that can be met. And you meet the enablement requirement on a plant patent by simply providing a picture of the plant. You are entitled to one claim, a plant as shown and described herein, and that gives you 20 years of exclusivity for a plant variety that is asexually produced from the patented variety. There are no maintenance fees in these kinds of plant patents.
We did have a couple of questions
Oh, sure.
on this slide.
Yep.
So, first one, and this was all from one person. How distinct does a varietal need to be considered patentable?
So for a utility or plant patent. Well, let's just say, so, okay, either way, you need to satisfy novelty and non-obvious. So novelty means the exact thing has not been in existence before. Non-obvious means that it is not obvious from what was in existence before. So if I want to patent a variety, one or two significant traits that are significantly different from the parent or from a SIB, we usually include data that would show that it's distinct from a SIB or a parent in the actual application. So it doesn't take a lot as far as obviousness goes. And I would say that's probably the same for your plant patents as well as your utility patents. You just need to be distinct and non-obvious in a couple of traits for patenting a variety that is the result of traditional breeding. Different standard of utility or non-obviousness for something like a gene that is isolated and sequenced. But right now we're concentrating on exclusively plant varieties.
Okay. And then their second question was, how early should we speak with an attorney? So does the plant need to go to fruit or go through a year cycle first? Is it ever too late to protect a varietal?
Yes, it can be too late because we have our utility patent statute, which applies to both plants and regular utility patents. We have an on sale bar date. So if it's publicly used for more than a year before filing, you are barred from obtaining patent protection. So certainly before anything gets into the marketplace, certainly before anyone can access the plant itself for asexual production or seeds of the plant to produce it. So definitely before a first sale, hopefully before any public availability or access to it, which can, I think you should probably start talking about attorney when something's available, ready for release. You don't have to have commercial quantities available. We do need to have either a tissue culture for an asexual plant or 625 seeds available for a seed reproduced plant that we can use to make our deposit. So utility patents can be used can also be used in addition to plant patents for asexual plants. So asexually produced plants can be the subject of a utility patent, can also be the subject of a plant patent. Sexually reproduced plants that are seed propagated can only be patented by a utility patent. The benefits of utility patents, as we said, they're the gold standard because you can have all different kinds of claims. You can claim generally about 2 generations out from your variety through crossing. You can get a claim to inserting transgenic traits, inserting additional traits. And we'll look at some of the claims that you can get for utility patents here in a second. And we need detailed description of the plant as well that we will include. Plant-related inventions can include transgenic plants, genes, proteins, and molecular markers. But right now I'm trying to focus a little bit on just plant varieties that are the result of traditional breeding. So this was the case that we had where it went to the Supreme Court to decide, should we be able to have utility patents on plant varieties that are the result of traditional breeding, or should those only be available for plant variety protection certificates, which is another form of protection that is managed by the United States Department of Agriculture. That's a whole nother regime of protection that's available. So when I have a variety that I want to protect for that is the result of traditional breeding, what kinds of claims can I get? What kind of protections can I get? And this is primarily for seed propagated plants. You can protect the plant. You can protect seeds from the plant, which is actually the next generation out. and you can protect the seeds that will produce that plant. You can protect F1 progeny. You can protect plant parts, so things like pollen, things like perhaps the pericarp tissue, the fruit, those kinds of things can be protected under your utility patent. You can protect transgenic conversions. You can protect production methods, new methods of plant breeding from that variety used as a parent in a cross, methods of use of the plant in generating new plant varieties, and also the harvested product as it relates to that product that was developed from that original seed. For example, in a wheat case, I might also protect the flour. Perhaps even if there's some really important trait, I could protect bread that had been made from that variety if it had a beneficial, unique trait. And then here are some examples of claims that have issued in various, and these are sort of standard claims that issue in a utility patent for a plant variety. Another area of protection for plant varieties where we're protecting the whole entire variety itself is to protect a trait. For example, if I, through traditional breeding, through mutation breeding, what have you, have introduced a trait to a plant or a plant variety that never existed before, I can patent that trait. Traits are not as easy to patent because we need to be able to establish that this trait would not have come into existence but for the act of the plant breeder. So things like mutation breeding, where we intentionally introduce this mutation, those are ways that we get patents to traits. Also, what a lot of people are doing right now is they look for exotic sources of germplasm that might have a trait, but in a background that is not economically viable for commercial production. So they can breed that trait into a commercially viable commercially viable variety, and now patent the trait as present in a commercially viable variety that is adapted for commercial growing of a particular plant or corn, what have you. So here's an example of a trait claim that issued in a patent, a carrot plant with average lycopene content, and then the sweetness, the Brix level. And so you can patent that trait if you can establish that that trait never existed before, but for your breeding. We can patent traits as a result of breaking a linkage. For example, if here where we've got a particular allele that traditionally coexists with another detrimental allele, breaking that linkage between the two so that we can claim one apart from the other in the particular plant. Recombined introgression, where a chromosomal segment is introduced. A new quantitative trait locus. So for breeding and selection, if you have a QTL that is in linkage disequilibrium with a trait that you want to integrate, you can patent that QTL for use as a marker and methods of using that marker. And then here's the thing that I was talking about earlier, where we're trying to get away from transgenics, maybe to introduce new traits. So we're looking for an exotic source of germplasm. So here they found this accession P197088 that had this resistance to downy mildew, and then bred that into a variety that could be reproduced. So now we've got this variety where we have a consistent reproduction of the traits of the variety that also now have the downy mildew from that original unique accession. So we deposit that accession and claim an exclusive right to that as a source of the resistance. Some of the pitfalls that people run into with protecting patenting varieties is where did we get the germplasm from, the original germplasm, and did we have the rights to breed with that, so that any resultant varieties can be patented. So that is something that we always need to look into, to make sure. For example, a lot of people that are patenting varieties in the cannabis area where it was illegal, they might have gotten the source from some public accession that was just out in the wild. Ditchweed, for example, they might have started breeding with something like that. So we need to know, and we need to find a way to assure that we had the rights to originally start breeding with that before we developed our variety. So where the source material is always important in knowing what you can and can't do, and to protect your results of your breeding. So now from utility patents, which I consider to be the gold standard, I think most intellectual property people do, we can go over to the plant variety protection certificate. And I think most breeders are familiar with PVPs. That was sort of the traditional way to protect things before 1985, and also before 2001, when our Supreme Court decision came out. PVPs are certificates issued by the United States Department of Agriculture. They issue more quickly than utility patents. Some people think they're less expensive, but I think if we can look at some of the numbers, they're not necessarily that much less expensive than a utility patent. And one of the things that I learned from this, I'm considered a special employee of the USPTO with this Public Advisory Committee, is that the USPTO keeps filing fees very low. And they do not break even on a utility patent until the second maintenance fee is paid. Whereas a PVP, you pay for everything up front, and they are a direct cost recovery. So PVPs can be initially at least as expensive, or perhaps maybe I would say more expensive, but close to as expensive as a utility patent. The main issue with PVPs, and why I would always recommend a utility patent if possible, is the research exemption that PVPs allow. They allow breeders to research and develop new varieties with anything that is PVP. There's also a, which is also called the breeder's exemption. There's also a saved seed exemption, which is not quite as problematic. So for a PVP, it must be distinct, uniform, and stable. Note that there is no non-obviousness requirement for a PVP. So a utility patent need not just be distinct, it needs to be non-obvious. So a PVP might be a little bit easier to obtain. It's not quite the hurdle that a utility patent is. Your PVP, you must disclose your breeding history, which we do not necessarily have to disclose in a utility patent application. Length of protection is 20 years again, and it stops people from marketing, selling, and reproducing the variety. And it also, in some circumstances, includes essentially derived varieties. So the 2018 Farm Bill expanded PVP protection, and then it started to allow PVPs for asexually and commercially reproduced plants. Before, it had only been available for sexually reproduced plants. So now we have it for asexually reproduced plants. And the 2018 Farm Bill also allowed PVPs to be issued for hemp, which is cannabis that has less than 0.3% THC. So the thought behind the expansion of the 2018 Farm Bill to asexually produced plants was thinking that the plant patent, which we talked about earlier, that relates to asexually produced plants, did not cover as, quote, essentially derived varieties, whereas the PVP does protect against essentially derived varieties. So there was a thinking that perhaps this was broadening the coverage that was available. My answer to that would always be, whether it's asexually produced or sexually produced, get a utility patent. Your utility patent is always going to have broader coverage than a PVP or a plant patent. This goes into the research exemption a little bit. The other thing, having gone through litigation of a PVP certificate, there is an absolute dearth of case law for trying to enforce a PVP against a would-be infringer. We're not even sure in the United States who has the burden of proof to go forward with a claim. Whereas on a utility patent side, there's hundreds and hundreds of years and thousands of cases that establish what kind of burden of proof there is, what is considered infringing. All of that kind of information is readily available, as opposed to a PVP where we're going into court and we don't even know how to write a jury instruction because we're not even sure what is needed to prove infringement or to prove that something is a copy of what we PVP'd. So here's what I was alluding to earlier, the difference in costs. As you can see, the filing fee for a utility patent for a small entity is $785, where for a PVP, it's $4,382. Recording the assignment, $41. Then preparing an assignment, I put $300. That's going to be something that your outside counsel would do. Preparing a PVP application generally is around $1,300. A utility patent on a plant variety that is a result of traditional breeding will generally cost around $3,500 to $4,000 to prepare of attorney time. There might be some office actions in a utility case. You also get them in PVPs, but it's much less formal. At PVP, you generally just get an email and they want to see some additional traits. Utility patent, we may be arguing a little bit about scope of coverage because, as I said earlier, there's all kinds of claims that you can file in different aspects of the plant that you can protect. So we might have to go back and forth with the patent office a bit. A utility patent also includes a deposit of seeds or a deposit of a tissue culture from which the plant can be regenerated to satisfy the enablement requirement. The PVP for now, for the seed deposit, that's included within the $4,382. When looking at an asexually produced plant, the deposit requirement has been put on hold because they're not quite sure how to handle the situation because not all plant varieties can be tissue cultured and then regenerated. So as of right now, for an asexually produced PVP, there is no deposit requirement. It is waived unless the USDA office for some reason wants to have access to the plant material, and then you need to provide that. Maintenance fees for utility patents are due the 4th, 7th, and 11th year, whereas for PVPs, obviously, there's no maintenance fees. So when looking at all of the different routes of protection that are available, you can see that there are a lot of different options for anyone to consider when they're looking at protecting a plant variety. If it's an asexually produced variety, you can get a PVP. You can get plant breeders' rights if you want to file internationally. You can get a plant patent under the 1930 Plant Patent Statute, or you can get a utility patent. For sexually reproduced plants, you could get a PBR, again internationally, a PVP of the variety, or a utility patent to the variety. I would also note that when we're talking about international, and I'll get into that in a little bit, Canada also, in addition to the United States, offers utility patent protection for plant varieties that are the result of traditional breeding. So the US and Canada are the two countries that allow for utility patent protection. And when you can get utility patent protection, I'm always going to urge that you seek utility patents. Other options for international protection, besides if you want to go outside of Canada, would be UPOV and plant breeders' rights. And that is the US enactment of this is the Plant Variety Protection Certificate. And UPOV generates the guidelines for implementation of plant breeders' rights by country, or for everyone to use, and country by country has to enact their own legislation. So it is really complicated because the countries vary in little bits by how their particular enactment of the UPOV was generated. So this began in 1961, and it's been revised in 1972, 78, and 1991. The 1991 provision was particularly relevant. That's where it added in essentially derived varieties for protection under a PVP. So the rights are granted in a PVP to the owner of the breeder or the owner, and they're designated similarly. It's an exclusionary right over propagating material of the variety. There are bar requirements, just like in the utility patent statute. It can't be used for more than 1 year in that country or more than 4 years anywhere. And those change based upon whether it's a woody tree or vine or just a normal plant, such as a blueberry or something. The difference between the two acts, 1991 was where they enacted the farmer's exemption, which allows a farmer to reproduce an amount equivalent to what was purchased for their own personal use. The breeder's exemption, which allows plant breeders to use the material once they have gained access to it to breed for new varieties. And I cannot tell you how many times I have had clients come to me and say they want to enforce their PVP rights against somebody who bred with their material. That is allowed under the PVP. You can ask for a royalty and use that to enforce a royalty exemption from the people that are going to sell their developed variety, but it does not stop anyone from breeding with that variety. Now, a utility patent, on the other hand, is going to stop somebody from breeding with that variety, from crossing with that variety, from inserting a transgene into that variety. A utility patent will be able to stop those things where a PVP does not. The 1991 enactment also expanded coverage to harvested materials from plants, expanded coverage to an essentially derived variety, which is not defined in the statute. And if anybody has been following this through the UPOV meetings, they're trying to issue some guidelines about what is considered to be an essentially derived variety and therefore falling under the PVP original certificate as opposed to something that could be protected in its own right. And there's a lot of discussion and debate going on about what is considered an essentially derived variety. I think one thing that we can say for sure is that an essentially derived variety would be one where perhaps one small transgene is introduced. And then other than that, it's identical in every form, at every locus to the original parental material. For example, a T1 would be essentially derived. How far away you can get from something that make it be outside of essentially derived. We've had case law that has evolved very differently in Australia and the Netherlands. So it varies country by country. And in the United States, we've never had a case that has gone to court to determine whether something was essentially derived or not. It also in 1991 expanded the protection to 20 years as opposed to 15 years. So when you're looking at international protection for plant breeders' rights, not every country has passed the 1991 revision, and this slide probably needs updated. I'm not sure how old this one is, But this, you need to know, first of all, whether it is under the 1991 version or the 1978 version to determine what scope of rights are available. And that's all I had, unless people have some questions about, I went through this rather quickly. So if there are questions about utility patents and what kind of protections and what's available for a utility patent, I'm happy to answer those, or any other questions.
Thank you, Heidi. Think one last question from before, and I think you kind of answered this, but what's the most common form of IP for a plant variety? And then a follow-up to that is, can a plant variety have more than one form of protection on it? So could you file a utility and a PVP, or, so that was that question.
Great question. And the answer is that is a long-standing doctrine of intellectual property, that different statutory regimes can protect different aspects of the same sort of thing. And one example that I give when I do presentations about this is a can of Coke, for example. So I might have a design patent on the design of the can. I might have a trade secret on the secret recipe for Coke, which is legendary. I might have a design, I might have a trademark on the use of the term Coke, or maybe the way that the bottle looks. So you can have overlapping forms of protection. So going back to that one slide that I showed earlier, if I've got an asexually produced variety, my options could include a plants patent, a utility patent, a plant breeder's rights, or a PVP, and those can all be part of for the same variety, because they theoretically protect little different aspects, and there are different things that are required for each form of coverage. That was one of the arguments that was in the JEM case, was that a utility patent requires one to enable the invention. We have to make a publicly accessible deposit for a utility patent. So we're putting that more into the public domain than for a plant variety protection certificate, but you can certainly get all forms of coverage. And there are advantages. If cost is no concern, I would generally recommend that we get a PVP protection first, because that's going to issue more quickly, and that's going to give you some initial coverage. A utility patent takes probably about 4 years to work its way through the patent office, so it can be a while before that issues and you get those additional protections. So most of your larger seed companies, your Bayers and your Cortevas, so on and so forth, would generally file PVPs as well as utility patents on every variety that is commercialized. We can also talk a little bit about for hybrids, because you can patent the inbred line, you can patent each of the inbreds that were used to create the hybrid. You can also patent the hybrid itself. So those are all things that need to be taken into account. So one plant might have several different patents or several different forms of intellectual property that relate to it, particularly if, for example, you've got a hybrid that is out there that might have BT resistance or some other transgene that has been introduced. Now we might have patents that relate to the transgene, as well as patents that relate to the variety itself. So there's all kinds of different layers of intellectual property protection, and that is the same whether it's a pharmaceutical, where you might have one transgene that is produced in a pharmaceutical that finds its way into a pharmaceutical product. The layering of intellectual property protection is common, and it happens in every area, and it happens in plants and plant varieties as well. And I'm sorry, Carolyn, what was the other question?
Oh, they had just asked what the most common form of
Oh.
IEP for plant variety usually is.
Yeah, and the most common, I think that most breeders are most comfortable with is your plant variety protection, your PVP. Because you just fill out those forms. I think plant breeders do it. Most people do it. The breeders themselves do it and apply for it. We can talk a little bit about whether or not that might be advisable. I would always want an attorney to just look at it briefly. But the most common is definitely plant variety protection certificates. That's what everybody's the most comfortable with. But it started, I think, back when, the early 90s, when the seed companies started filing on inbreds and hybrids and corn and wheat and soybeans. They started to see the additional protections that were available, and now it has been great fun to be in this area because plants patents are expanding into other unique crops, into your fruits and vegetables, for example, blueberries and you name it, and any plant vegetable is also patentable, or as are fruits, trees. All of those things over time have become the subject of utility patents. And I suspect that they're going to be the norm for anything that is valuable, that is going to be around for 5 to 6 years. Some of those landmark varieties that really are an advance in yield or in some important trait or combination of traits. I think those utility patents are going to be the most common for those kinds of plants and varieties. As plant breeding gets more sophisticated, we're finding more and more that the people are tending to go towards utility patents because of the additional protections that they provide.
Thank you for that response. So the last one I'm seeing right now is back on international protection. Can you elaborate on the case law from the Netherlands? Is the US or Netherlands more favorable for plant breeders in terms of protection of IP?
Okay, that's a different presentation.
Okay.
I gave that one for Autumn a few years ago, and it related to so the Netherlands, and there were several cases that related to baby's breath, and whether one company had offered for sale something that was essentially derived from another protected baby's breath PBR certificate. And in one country, the exact two parties, the exact two varieties, it was found to be essentially derived, and therefore the second variety owed royalties back to the first person who developed the first variety. And the exact same two parties, the exact same two varieties in another country, it went the reverse way. And it had to do with who had the burden of proof, whether you have to prove something is an essentially derived variety, or whether the defendant has to prove that it is not an essentially derived variety. And it also went into, and there is some case law about what is essential to a plant to establish that it is essentially derived. Can it be a single feature that is copied from the plant, or that is used in a resultant created variety? Is that one trait? Well, if the trait, some of the case law says that if the trait is the single most important part of that variety, it can be essentially derived with only that trait incorporated. Or it can, and so it depends on which country and how the case law evolved. I do have that information in another presentation that I can make available if anybody wants to dive into the case law, but it really does vary country by country, just based upon just the smallest things about, who has to the burden of proof in going to the judge. So it's really different country by country. And in the United States, we have absolutely no case law.
Thanks. Yeah, I think that person, they've not said anything, but if you do have that presentation available, I can send it out to them.
Okay, yeah. It's,
Okay.
yeah, it's available in the audit materials.
Okay.
But yeah, I will get that out. Yeah.
Okay. Okay. And then one more popped up. Can you get plant protection on a plant that's illegal in the country? So opioids, marijuana, et cetera.
Um, so you can get utility patents on things that are not legal to sell. The idea is that that what makes something patentable. For example, all kinds of drugs, heroin, or would be illegal to sell, but you can patent the chemical components associated therewith. The patent office does not evaluate whether something is legal to be sold or not, because, as you know, laws evolve and develop. So as it has for cannabis. It's really been interesting to see how this has all developed, but you can absolutely get a utility patent on cannabis that with a higher than 0.03 THC content that may not be legal to sell in certain states and may be legal to sell in other states. The patent office does not evaluate that aspect of it. So the answer is yes, you can patent a plant variety of marijuana that has a high THC content and get a utility patent on it.
Okay. And then I think the last question is just if you can send out a copy of this presentation,
Oh.
And if yes, I will send it out to everyone
Sure.
after we wrap up today.
Yep.
So, okay, any last questions? Okay, I'm not seeing anything. So just want to say thank you again to everyone for joining, and thank you, Heidi, for this presentation. Lots of information in there. I think that'll be very valuable for everyone. So it's definitely great to have you on with us today. So
Thank you for the opportunity. Happy to answer any other questions offline.
thank you. Have a great rest of the week, everyone.